this portion, I will be going live on the Facebook as well, Islam, for this lesson, for today's lesson. Give me 1 second. By setting up. Okay, we're now live. Let me share my screen. If you can see my screen, drop a 1 in the chat. We only gonna be live momentarily. It's not gonna be for the entire length of the rest of the class, but just a small portion to share with the public. Islam. If you have any questions, do throw it in the chat. Islam, they will be read after the class. So after we, go through this, you may formulate a question. Islam, throw it in the chat. Write it down, and we will read it. Islam. So we talking about the commercial administrative process today. A lot of us have misconceptions about it. So hopefully this breakdown can help us advance understanding, bring clarity, and where we can use this in all situations from courts to alleged creditors. Islam, understanding the three portions to the administrative process, the key laws, the UCCs is what we are be using. Um, Understanding the conditional acceptance, the opportunity to cure, and the notice of fault. A lot of people say they know it, but even me, I had to go back and really understand which each process was, why each notice was actually important, and what does it does. How do we bind the other party to the actual agreement? Because a lot of times we say, well, I sent him the conditional acceptance and they acquiesce, and so they agree, and that's not always recognized by courts. And what we want to do is move with precision. What's the key word? Precision. Islam. Okay, so this is educational notice. This materials for educational and informational purposes only, is not legal advice, tax advice, or a guaranteed method to eliminate lawful debt obligations. Banking disputes, collections, and credit reporting issues are governed by federal and state laws, contracts, and court procedures. Individuals should consult licensed professionals where appropriate. Introduction. The administrative process is fundamentally a structured paper trail method used to create a documented record of communication, disputes, requests for verification, opportunities to cure alleged errors or inconsistencies. The purpose is not merely to argue, but to establish evidence of good faith conduct, preserve rights, request records, and organize a factual timeline. A properly organized administrative process typically attempts to accomplish the following: identify the parties. Who's the parties? Islam. And account at issue. You have to clearly identify the parties. You're never a party. You're the individual who's the representative of one of the parties. Islam. So knowing our place, knowing everybody's place falls in previous lessons we just covered of holder due course, etc. Islam Johnson Bay, you were saying something more?
No, sir.
Okay, Islam.
I mean, put myself on mute though. It's probably background.
Islam. Definitely mute everybody, mute yourselves if you're not speaking. Um, Next is to clarify what is being disputed. Islam. You have to be clear, precise. According to the agreement, what is actually being disputed? Can't just make general disputes. Well, you said you didn't have the contract, blase Skippy. We have to be more detailed. Islam, we have to hold people accountable and clarify the what. What is the what? Clarify the what is being disputed. Okay. Request supporting documentation. Okay. Leon Roel just did a good job of telling us the documents, the requests, Islam to support a valid claim. If they don't have these supporting documentation, then they don't have a valid claim. Preserve evidence for future litigation and arbitration. Demonstrate good faith efforts to resolve the dispute privately. A lot of us don't understand that when we're dealing with courts. We are moving in good faith efforts to resolve the dispute privately because courts only adjudicate for controversy. But when we use the administrative process in the private, then we can wedge an agreement, which kills the controversy, which is subject matter jurisdiction, because if the courts have no controversy, they have no jurisdiction. A lot of us just say, well, I went to court and said they have no jurisdiction. Well, it was controversy. You said not guilty, they said guilty. That's controversy. Where in the private did you make good faith efforts to dispute it? Because courts recognize private agreements, private persons. See, the law does not aid private parties, aids the public. So we must move in good faith, which is equity. Establish whether the responding party can substantiate its claims. That's making them prove their claim. Can they prove their claim? Can you establish that? Do you have evidence? Have you preserved evidence for this? For future litigation and arbitration according to UCC 1-201 in the sense of judicial proceedings. Actions. When I ask somebody, what's the cause of action? Islam, this is what I mean. What is your cause of action? Can you demonstrate and establish this with the preserved evidence? The process generally consists of three major steps. Number one, the conditional acceptance. We talked about the acceptance. We talked about the condition. We talked about the additional terms and rejection and the different elements that goes into an acceptance and how we have to be more precise and request for full accounting. So we're going to go over that today. What actually do we request? A lot of times when we're in different situations, we're requesting things that's not even binding. Are we requesting that chain of title? Islam, they have to make the connection. The proof of claim, the burden of claim is not on us. We too busy trying to prove who we are. Well, I'm prove I'm a Moor. I put my status on the record, but the burden of proof was never on you. You wasn't making the claim to be a Moor against somebody else, and they had to compensate you for being a Moor. That wasn't the claim. Somebody made a claim against you, and they have to prove that claim. We have to know liability and penalty of perjury. Islam, because if they can't prove their claim, we found out that that's perjury. And this is why affidavits and unsworn declarations is so important, because they have to.
I dropped it in the chat too, Grand Sheik.
Islam, please hold comments though while I'm speaking. I appreciate that. Thank you though. We have to establish good faith so we can switch liabilities. Islam, request the proper documents, request full accounting. Some people just say, well, I requested this, I requested that, but was that full accounting? Because just because you requested chain of title, is that full accounting? And what is the account? And why are you even requesting that? What gives you the right to request anything in the account? And what relation do you have to that? Because it's all about the relation. We have to express the relationships. What relationship do you have to request these documents? So we have to know we are the beneficiaries because we just found out earlier Allah is the beneficent. Number two, accord and satisfaction, a conditional settlement offer, which is the opportunity to cure Islam. We have to give them opportunity to cure once we request full accounting. According to the provisions of UCC 3-311, the accord and satisfaction, the conditional settlement offer, sending them an instrument, something of value, consideration, something to exchange, to settle and set off and discharge. Tender of payment according to UCC 3-603. Islam, you want to be familiar with these provisions so you can use them for your remedy. Then number three, the dishonor, the notarial protest and record preservation. Islam, these protests under UCC 1-308, you want to hold them on a protest. You want to have evidence of dishonor under 3-503, 505, pardon self. You want to have evidence of the dishonor with the notarial protest. And these are the three stages, not three just letters, but these are stages. These are stages in your process and administrative process because each one of these stages are very efficient and effective if we use them properly. And they apply for 99% of all our situations. The strength of any administrative process depends on accuracy, professionalism, documentary evidence, timelines, consistency, and record keeping. Emotion does not create leverage. Documentation creates leverage. Step one, the conditional acceptance and request for full accounting. Purpose of step one. The first step is not an outright refusal. The first step is a conditional response. A conditional acceptance is essentially saying, I am willing to address this matter upon verification, a substantiation of the claim. This preserves professionalism while placing the burden on the claimant or financial institution to produce records. In banking disputes, debt collection matters. Repossession matters, mortgage disputes, and credit reporting disputes. The key issue is often documentation. The objective is to obtain a complete accounting and documentary verification. What is full accounting? A full accounting is the detailed breakdown of the alleged obligation, transaction history, ownership history, fees, balances, credits, and supporting records. Islam, let me say that again. A full accounting is the detailed breakdown of alleged obligation, the transaction history, ownership history, fees, balances, credits, supporting records. The purpose of requesting a full accounting is to verify the accuracy of the balance, identify errors or inconsistencies, determine who owns or services the account, determine whether the fees were properly assessed, preserve evidence, identify possible violations of law or contract. A full accounting request should be specific. Vague requests usually receive vague responses. What to request from banks and financial institutions? Number one, complete payment history. Request every payment made, date of each payment, method of payment, allocation of payments, principal versus interest breakdown, escrow allocations, late fee allocations, return payment records, internal payment adjustments. Islam, that's the payment history. That's just one of them. What we're requesting. Most people would probably send this and say, well, I requested full accounting. No, that's not full accounting. That's just payment history. Islam, are you requesting the payment history? Purpose. This identifies misapplied payments, duplicate charges, unexplained fees, and accounting inconsistencies. Number two, we want to complete account ledger. So this is separate from payment history. This is the account ledger that we are requesting. What are requesting? General ledger entries, transaction ledger, internal accounting records, debit and credit entries, charge-off records, reversals and adjustments, collection notes, internal account comments. So, purpose, the ledger often reveals whether balances were altered, charged off, sold, transferred, or modified. Number 3, original contracts and agreements. So we are, number 1, payment history. Number 2, the ledger. Number 3, contracts and agreements. Requests, original signed agreement, amendments or modifications, terms and conditions, security agreements, promissory notes, guarantee agreements, arbitration provisions, electronic signature audit trail. Purpose, the institution must generally be able to identify the governing agreement and applicable terms. Number 4, ownership and transfer history. We want to request the chain of assignments, the sale and transfer records, pooling and servicing information if applicable, name of current creditor, name of servicer, authority to collect, purchase agreements related to the account, records showing standing to enforce. Purpose, this clarifies whether the entity contacting the consumer actually serves or owns the account. Number 5, validation of fees and interest. Request itemization of fees, calculation method for interest, APR calculations, late fee authorizations, escrow shortages, insurance charges, legal fees, collection fees. This identifies inflated balances, unauthorized charges. Number 6, credit reporting records. We want to request Metro 2 reporting data, furniture records, date of first delinquency, records sent to credit bureaus, investigation records, verification procedures, identity verification methods. Purpose, this helps determine whether inaccurate credit reporting exists. And y'all can screenshot these as well. Islam. Number 7, communication logs. We want to request collection call recordings, internal call notes, corresponding logs, emails, notices sent, repossession notices, default notices, acceleration notices. This creates evidence regarding compliance with notice requirements. Islam?
Islam.
Number 8, security interest documentation. Request UCC filings if applicable. Security interest perfection records. Collateral descriptions. Repossession authorizations. Title records, insurance claim records. This helps determine how the creditor claims their interest in collateral. They have no interest, then they're not the real party of interest. How to structure the conditional acceptance. A professional conditional acceptance generally contains, number 1, identification of parties. Number 2, identification of account. Number 3, statement disputing or questioning the claim. Number 4, good faith request for verification. Number 5, request for accounting and records. Number 6, deadline for response. Number 7, reservation of rights. Number 8, Notice that records may be used in future proceedings. The tone should remain professional and factual. Avoid threats, emotional accusations, or unsupported legal conclusions. Islam. Number two, step two, the court and satisfaction, conditional settlement. Purpose of step two. Once documentation is reviewed, the second stage may involve attempting to resolve the dispute. This includes settlement offers, payment arrangements, conditional payment offers, requests for correction, dispute resolution proposals, arbitration demands where applicable. Under UCC 3-311, accord and satisfaction generally concerns the settlement of a disputed claim through a good faith tender accepted by the claimant. However, whether a particular instrument or tender legally discharges the debt depends heavily on facts, applicable law, and court interpretation. There is no universal magic instrument that automatically eliminate debt obligations. Islam. What should be included in a conditional settlement offer? A proper conditional settlement communication may include identification of the dispute, identification of accounting discrepancies, statement of disputed amount, proposed resolution, request for written acceptance, reservation of rights, request for correction of reporting settlement deadline. The objective is to demonstrate good faith effort, willingness to resolve, reasonableness, evidence of an attempted cure. Islam. So this is the opportunity you are giving them to cure, settle the debt by tendering them an instrument in good faith efforts. Common issues identified during step two, inaccurate balances. Examples, duplicate fees, improper interest, incorrect delinquency dates, misapplied payments. Islam. Number two, lack of documentation. Examples, missing agreement, missing assignment records, incomplete payment history, failure to validate the debt. Number three, credit reporting errors, incorrect balance, incorrect status, reagent of debt, duplicate reporting, inaccurate delinquency dates. Number four, procedure violations, failure to send notices, improper repossession procedures, failure to investigate disputes and collection violations. Islam. So these are the things that they need to be curing, that we need to be requesting. Step three, dishonor and notarial protest. Purpose of step three, if the responding party ignores the request, refuses to answer material questions, sends incomplete responses, fails to produce records. The final stage is often record preservation. This stage is not about theatrics. It is about documenting dates, communications, non-responses, incomplete responses, and refusals. A notarial protest and affidavit process may be used in some contexts to preserve evidence that notices were sent and responses were absent or incomplete. The value is evidentiary. It does not automatically create judgment or eliminate obligations. What to document? Step three, document date notices were mailed, tracking numbers, delivery confirmations, copies of all correspondence, copies of all responses, missing responses, incomplete responses, affidavits of mailing, affidavits of non-response. Islam, the role of arbitration. If a governing agreement contains an arbitration clause, Disputes may sometimes proceed through arbitration rather than court. This may include consumer arbitration, contractual arbitration, debt disputes, and billing disputes. Always review arbitration clause language, delegation provisions, governing rules, filing requirements, and fee schedules. Tender by performance. Tender by performance generally refers to performance or attempted performance of obligations. Examples include providing requested documentation, responding within deadlines, making agreed payments, complying with settlement terms, producing records. Good faith performance strengthens credibility in any dispute. Important record keeping practices. Keep copies of all notices, certified mail receipts, tracking confirmations, fax confirmations, email records, phone logs, notes from conversations, chronological timeline. Important legal framework to study. So make sure y'all screenshot each one of these. You got the UCC provisions. You got 3-311, accord and satisfaction. You got 3-603, tender of payment. You got 9-210, request for accounting. 3-503, notice of dishonor. And 1-201, the general definitions. Federal consumer laws that you can apply. The Fair Credit Reporting Act, FCRA. The Fair Debt Collection Practices Act, FDCPA. The Real Estate Settlement Procedures Act, the RESPA, Truth in Lending Act, TILA, and the Equal Credit Opportunity Act, ECOA. Islam. Final principles. The administrative process is strongest when the facts are organized, the records are preserved, the requests are specific, the communications are professional, the timelines are documented, the claims are evidence-based. The goal is not to overwhelm the other side with rhetoric. The goal is to build a clean documentary record. Professionalism, documentation, and precision carry more weight than unsupported theories. A disciplined paper trail can become valuable evidence in arbitration, regulatory complaints, credit disputes, civil litigation, consumer protection claims, and settlement negotiations. Record first, evidence second, arguments third. Islam. So what we have here is the full administrative process in a nutshell. Islam. To understand the principles of the administrative process, not just the copy and paste, the conditional acceptance, opportunity cure, but understanding which stage and what it means to go through each stage of this. Islam. How do we assert our rights and get remedy? Because each one of those can give us remedy. You don't have to get to step 3 to get the remedy. Get the remedy to step 1. And each one of them can be held as evidentiary evidence. So if I sent to a conditional acceptance upon proof of claim and you fail to answer that, I already got everything I need right there. That's you in fault at that moment. Now, from there, I'm going to give you an opportunity to cure and tender you a payment with an instrument 3-311. Let's look at that one more time. Let's go through those laws. Break it down. We're going to request for full accounting. Islam, that means request the record. Request for an accounting record authenticated by the debtor. We have to understand these. What are we requesting? I listed 8 things. that's included in the full accounting, 9-210. Islam. Opportunity curd according satisfaction by use of instrument 3-311. Islam. It says, hey, if a person against whom a claim is asserted proves that that person in good faith, tendered an instrument to the claimant as full satisfaction of the claim. 2, the amount of the claim was unliquidated or subject to a bona fide dispute. And number 3, the claimant obtained payment of the instrument. The following subsections apply. Islam. It says B, unless subsection C applies, the claim is discharged. Islam, the claim is discharged if the person against whom the claim is asserted proves that the instrument or accompanying written communication contain a conspicuous statement. Islam, a conspicuous statement under UCC 1-201 to the fact that the instrument was tendered as full satisfaction of the claim. Islam. So this is evidence. Last step, the notarial protest. Notice of dishonor and evidence of dishonor. You go to 505 for that, actually. That's that. Let me just skip along. We can go to evidence of the dishonor, 505. It says the following are admissible as evidence and create a presumption of dishonor and of any notice of dishonor stated. Go down B. A protest is a certificate of dishonor made by the United States consul, vice consul, or notary public, or other person authorized to administer oaths by the law of the place where dishonor occurs. It may be made upon information satisfactory to that person. The protest must identify the instrument and certify either that presentment has been made. Islam, presentment falls under which article of the Constitution? Amendment. Fifth Amendment, presentment or indictments. They have to answer upon presentment or indictment has been made, or if not made, the reason why it was not made, and that the instrument has been dishonored by non-acceptance or non-payment. The protest must also clarify that notice of dishonor has been given to some or all parties. Islam. So it's all about compiling the evidence to be used against defense of any claim, to discharge any claim. We have to know these offers are being sent to us. UCC 3-603, tender of payment. If a tender of payment of obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of tender is governed by principles of law applicable to tender of payment under a simple contract. If the tender of payment of obligation to pay an instrument is made to the person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of an endorser or accommodation party having the right of recourse with respect to the obligation to which the tender relates. So we have rights of recourse that we must enforce. with the tenders of these payments. When we are accepting and returning things, what are we doing? We are tendering. They have gave us an offer, and then we accept that offer and give them a counter offer. That's a tender. We are offering to pay. We are offering to settle. If that offer is refused, then you discharge. So we have to understand these principles of the UCC. We have to understand the constructive language of the UCC and how that falls, because the construction is the constructive trust that was formed when we enter into all these agreements of the parties. The straw man and the corporations are the parties who enter into agreements, and we are the individual authorized representatives, but we have to liberally construe the UCC, because the Uniform Commercial Code must be liberally construed. Islam, you cannot literally construe this. It's not literal what you're reading, it's liberally. Islam, so that means it's not exactly literal, symbolic meanings to this. And the pride to promote its underlying purposes. This is not surface level stuff. It has underlining purposes and policies that's underlining, meaning that it's more to what you see when you're reading these things and applying these things, and we must interpret these things to the other parties. Islam, this is the construction and the supplemental principle. Supplemental means something is missing. We must supplement it with the principles of law. These agreements are missing things. We read what's a valid contract. There are 4 essential elements that are missing. And we must supplement that so we can form contracts so they can discharge our obligations. Under displaced by the particular provisions of the, unless displaced by the particular provision of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause of actions, supplement its provisions. Islam, so wherever it's missing, you must supplement these in the contracts, the principles of law and equity, the law merchant, Islam, and the common law to capacity to contract. That must be supplemented in your writings. Islam. So we have a lot to learn, a lot to do. We have to understand these constructive language. We have to understand the language arts and the constructive trust and the roles we play in the constructive trust that's being formed. Where do we stand? How do we reverse these things? How do we respond? Do we know how to respond? That was one of the questions of homework. Do we even know how to respond? Islam. So let me close this out, and I'm going to open the floor for questions. I'm going to stop the live stream now. Islam.